we'll go through this. Let's see what we got here. All right, so one of the things every year that does change is wage and hour laws. And the minimum wage has changed in California. In 2021, you know what it was. In 2022, starting January, if you have 26 or more employees, it's 15 an hour. And for 25 or fewer, it's 14. And by next year, it'll be $15 an hour for all employers. And after that, it will adjust by the rate of inflation as we go along. So this means you have to also pay attention to exempt employees, those who are administrative, executive, supervisors, professionals, and the exempt employees must get twice minimum wage. So it is right now it's $30 an hour for larger employers, and 28 for the smaller ones. 62,400 is what you have to pay an exempt employee if you have 26 or more, and 58,240 if you have under 26. And overtime now is 22.50 if you have 26 or more, and 21 if you have less. And don't forget the local minimum wages. And throughout the state, cities and counties have their own minimum wages. Like Oakland is $15.06 an hour, and Santa Clara is $16.40. And there's also special rates for computer professionals and physicians. So if you have questions on those, you can certainly let us know. You should be used to these kind of changes by now. Okay, so California Family Rights Act, you familiar with that? Used to apply to 50 or more people. That was changed the last year to 5 to 19 employees. You must provide people leave to 12 weeks, unpaid, to care for parents, children, their own serious illnesses, medical conditions, to bond with their child, the birth of a child, adoption, and so on. They made a correction in the law. There was an obvious oversight. They left out parents-in-law. The old law, interestingly, had a definition for parents-in-law, but parent-in-law was not included in the list of people who can participate. So who you can care for. So that now is included. There's a list. You must allow these people time off to deal with it. We've had questions in the past. How do I know when I have 5 employees, for example? Just like we had questions, how do I know when I have 20 or 50? Actually, there's this formula to be aware of. If you have 5 employees or more in a 20-week period, not even consecutive, during a calendar year, you're covered by the CFRA. And the law says if you have 5 or more people current year, or previous year. So for example, you could have 5 employees and meet the test by September of 2021, let's say. Then you drop down to 3 employees. Well, they will be covered by CFRA for the rest of 2021 and all of 2022, because it's current year and previous year. Something to know about. The other important part of this new law is to help small businesses, employees have to go through a mediation program before they can bring a lawsuit. And if they do bring a lawsuit, employers can enjoin those lawsuits and require the mediation process. It just is sort of helpful. They're supposed to go through this process before filing suit, because many of these cases are just small and they can be handled through mediation. Safety, and this is a big one, safety and enforcement penalties. Right now we have 2 new Cal OSHA categories for penalties and violations. One is called the enterprise-wide violation, and the other is an egregious violation. These are new consequences, and they're effective January 1st. The enterprise-wide is if you have more than one location, and it's determined that you as an employer have a non-compliant policy or procedure, pattern of practice, that could be an enterprise-wide violations. And the penalty for these violations are $134,334 per violation. And the Cal OSHA can get an injunction and shut you down. They have new enforcement remedies if you have more than one location. So you want to take a look at your policies, you want to look at any written safety policies. We can assist you with that. Workers' compensation carriers often can assist you with that. There are companies out there that help you comply with OSHA and Cal OSHA, but that's an important one. Another one that's sort of new is called the egregious violation. And there are 7 different criteria. If you violate any of these 7 criteria as an employer, you can be considered an egregious violator, egregious violation. If you intentionally, voluntarily don't take action to correct violations, there's worker fatalities or serious illnesses, high rates of injuries, extensive history of prior violations. It's somewhat subjective. To intentionally disregard health and safety responsibilities. There's a number of categories. But the problem with this one is a violation is considered by every employee who's been exposed to a violation. So that's a penalty. So it's $134,340 per employee. $134,334 per employee. So you've got 20 employees, and you are considered an egregious violator workplace. Well, what's 134,000 times 20? It can put you out of business. So again, this is really very important, not to be ignored, and you need to make sure you're up to date and you're very consistent on how you take care of this. And also, we're all familiar with the concept of wage theft. That's a term that's used in the labor code and regulations. If you don't pay somebody properly, don't pay them proper minimum wage, or you don't pay them for their overtime, you don't pay them whatever they acquired under the reimbursements, that's considered wage theft. And there's civil liability and even criminal in the labor code. Hasn't been much of a deal as far as criminal goes. But now they've actually included wage theft under the definition of grand theft in the penal code. So if there's $950 or more for one employee, that could be considered wage theft. It could be, or if there's $2,350 for two or more employees in a consecutive 12-month period, misdemeanors up to a year in jail, or it can be charged as a felony as grand theft, 16 months to 3 years in prison. That's what you face, plus an order of restitution. Prosecutors can seek restitution. It's a serious matter. It's now grand theft under the penal code. Interestingly, it now includes independent contractors. So we can see problems with this. Suppose you hire an independent contractor, web designer, somebody like that, and they send you an invoice for $1,800. You say, that's too much. That's not what I want to pay you. It's not too much. We don't agree to that. I'm going to send you $1,500. Is that wage theft? And now you've committed grand theft, perhaps. If it's more than 950, discrepancy. If it's a contract dispute, uncertain. But you want to be very careful in hiring your independent contractors, working out how they get paid. It's a new one, new penalty. The labor commissioner, if any of you've been through the labor commissioner process, they would get a judgment against you and enforce it like any other judgment, which isn't easy for the employee to try to collect. Now, the labor commissioner has the authority to simply put a lien on your real estate, just a lien. And now you would try to sell or refinance, that lien's going to get paid, or it can be foreclosed upon in a relatively simple manner. So it's a new remedy that the labor commissioner has to help employees. This is an interesting one, statutory interpretation. Okay, you're all familiar with it, that if an employer doesn't provide meal breaks and rest breaks as required by law, they're supposed to pay a premium pay, an hour pay. And the statute for this premium pay talked about you got paid at the employee's regular rate of compensation. Well, there's other regulations that talk about overtime, for example, which uses the term regular rate of pay. So courts and employers would take the position that regular rate of compensation is different than regular rate of pay. So regular rate of compensation, they concluded, was your hourly rate. Your overtime rate, as you know, you have to include for that work week, the base pay, any non-discretionary bonuses, piecework, other commissions. It's all added to figure out what their regular rate of pay is to get their overtime. Well, somebody brought a suit and they said, you know what? The court concluded regular rate of pay, regular rate of compensation are synonymous. They're interchangeable. So therefore, for the missed meal break or rest break, it's the regular rate of pay, the same that you do for overtime. And it's retroactive. So you can maybe audit, go back, see about situations where you paid premium pay. Did you include other non-discretionary compensation for that period? You may want to go back and correct that. That's a new interpretation. Kind of interesting. Rounding for meal purposes. That's interesting. A lot of employers round, you might. They round a quarter hour up, quarter hour either way, 5 minutes, 15 minutes, 1/10 of a quarter of an hour. There's rounding. Well, can you do rounding for meal and rest breaks? Well, the Supreme Court of California, in the case of Donna Q versus AMN, said no. And it makes sense. Because if you look at the statutes and the regulations, labor code and regulations, wage orders that talk about meal and rest breaks, it says At the end of 5 hours, you must give somebody a 30-minute meal period. Well, that's very specific, 5 hours and 30 minutes. They talk about 10 hours, you get 2 meal breaks. But you can waive these breaks if you work less than 6 hours or a second meal period after 10 hours. These are very specific times. Therefore, you can't round. Then after the end of 5 hours, you get 30 minutes, not 29 minutes, no rounding, even though sometimes you round up, sometimes you round down, 30 minutes. So do not use rounding for meal and rest breaks. It's just best not to do them anyway, if you can avoid it. Just the actual times is important. That's kind of interesting. This is also new. When's the statute of limitations begins to run on a harassment claim? So claims under Fair Employment and Housing until this year, it was a 1-year statute of limitations. Now it's a 4-year statute of limitations. So this may not be as significant of a case. But this was a case where somebody filed suit against their employer for harassment because they did not get promoted. This employee would not sleep with the boss, didn't get promoted, and they viewed that as a form of sexual harassment. So they sued. Well, the question is, when did the statute of limitation run? And in this case, the employee was told in March of a certain year, you're not going to get promoted. Then in May of that same year, somebody else got promoted. A year later, in April, this employee filed suit. And the question was, did the statute run from a new person got promoted and you didn't? Was that the offense? Or when you learned you weren't going to get promoted? And the Supreme Court said, you either know or should have known. So if you're not promoted or you're being discriminated against, as soon as you begin to know that is happening, that's perhaps when the statute runs. These dates are very important. And as an employer, you want to kind of keep a record of these kind of dates, if you can. If you think there's an employee who might be bringing a claim, because the statute of limitations ends their claim. Electronic delivery of workplace notices. As you know, we have all kinds of stuff posted in our lunchrooms and on our walls in our businesses. And there's been an issue, what about people who work from home, remote workers? You have to mail those posters to them and have them posted up in their bathrooms. Well, you can deliver electronically. All the required posters and notices that you're required to post, you can send by email. It does not eliminate the requirement that you post these at your office. Got to post them in places of work. But you now, especially for the remote people, it now makes sense. You can deliver it by email. So it's a small change, and you should do that. And penalties have been increased for not doing it properly. So get posters, you can get them online, send them to remote workers so that they have them. Direct contractors, and back in January of 2019, statute passed that held contractors in the construction industry. They would be liable for unpaid wages of employees of subcontractors. For the general contractors, there's a scheme that was set up to monitor how you can tell if the subcontractors paying their wages and properly to their employees. This was changed effective January 1, 2022, that the general contractor, the direct contractor, is also going to be liable not just for the wages and fringe benefits, but penalties, and penalties are a lot, and interest. So they increase the liability of the direct contractors. You want to make sure you have a system set up where you monitor this. Okay, this is also a fascinating section. I teach business ethics at California Lutheran College and other places as part of business courses, and this has been an ethical issue. As you know, garment workers are underpaid; they're not paid properly. California is has the largest number of garment workers of any state in the country. LA alone, Los Angeles alone, has over 45,000 garment workers who are supposed to receive minimum wage, meal breaks, and rest breaks, overtime. Only about a third are paid properly. The rest are not. And they're working 10 hours, 12 hours a day. They're making $3, $4 an hour. If we take all the garment workers in the state of California, those who are paid properly and those who aren't, the average wage is $5.15 an hour. They're paid on piece weight. And you know, how many buttons you sew on, how many shirt sleeves you make, how many dresses you make is all piece weight. And that was a huge burden, obviously, and people couldn't make enough quick enough, and they ended up making $3, $4, $5 an hour. So piece weight now is no longer appropriate. You cannot charge, especially in the garment industry, piece weight. You're not paid them by piece weight. Unless you have a collective bargaining agreement, yeah, if you have a union and that's how they're going to be paid, sure. But now you're prohibited from doing piece rate. The other thing, though, that even as significant from an ethical standpoint is the brand generators. And brand generators are the retail stores, the stores where we all go shop and buy our clothes in. They were always, they were never accused of any violations, but they didn't manufacture clothes. They didn't hire anybody to manufacture clothes. And for 20 years, they would use layers and layers of subcontractors. So a major store, a retail store would hire a subcontractor, would hire another subcontractor, another contractor, and people be working, and they're the ones who violate the law. If anybody ever complained, a new contractor would come in. And people didn't complain much because from an ethical standpoint, you know what? We like to buy cheap clothes, so nobody really paid attention to this. Now, everyone in the chain is going to be liable. The major brand stores are going to have liability if they contract with anybody who then contracts with people to dye the clothes, sew the clothes, put on buttons, put on labels, whatever they're doing. Now they're going to be held liable too. So hopefully this will make a difference in the construction, in the garment workers' lives. So it's kind of interesting. Okay, so arbitration. The California's ban on mandatory arbitration is in flux. You might recall, because we talked about it back then, signed into law in 2019 and became law in January of 2020. AB 51, it prevented employers from requiring employees as a condition of employment, applicants or existing employees that keep their jobs to sign an arbitration agreement. It was mandatory arbitration agreements. And this code section said they're unlawful and there are civil and criminal penalties for requiring an applicant or an employee to sign an arbitration agreement. Voluntary is fine, but how you know voluntary from not voluntary, there's always an issue, but they were unlawful. Well, and before the law took effect, right at the end of 2019, U.S. Chamber of Commerce, other business organizations in California sought a restraining order and eventually got a preliminary injunction saying that law is invalid and hold it until we can litigate this further. Don't go into effect because it violates the Federal Arbitration Act. Federal Arbitration Act has been held over and over again to govern arbitration agreements. The Federal Arbitration Act and the federal courts are very much in favor of arbitration, and you can't prevent and you can't deal with it in a way because the federal government supersedes it. However, that the district court enjoined it, so that it was no longer valid. You could force people to have arbitration agreements. Then in September of last year, the Court of Appeals for the Ninth Circuit, of the highest court of appeals in our area, said, well, the Federal Arbitration Act doesn't really cover this because the AB 51 dealt with pre-arbitration. It's before you sign the agreement. And therefore, it's not covered by the FAA because before. FAA only covers arbitration agreements. And so you had this innocuous, this sort of incongruous situation where before the, you take an applicant, you take an employee, and you say, you've got to sign this arbitration agreement. They could sue you for violating AB 51 for damages, and it's also criminal liability. But once they signed the agreement, even if they felt compelled to do so, no longer liability. Now they're covered by the Federal Arbitration Act. There's no criminal, no civil liability. They can't sue you, and that agreement is enforceable. That makes no sense. So they are appealing that decision. The state is appealing that decision to the full panel of the Ninth Circuit, supposed to be like 13 judges. And during that appeal, the restriction is back into place. So there's no arbitration. You can't require arbitration agreements right now. So the lesson of this is do not require arbitration. If you want to have voluntary arbitration agreements, see your lawyer. We can help you. You got to make sure it's really, really voluntary, or there could be severe consequences. So that's very confusing, but that is how the courts work. I hope you understand that. All right, so now we're going to turn to the next half of our program, and Ted will take over. And when he's done, we might have time for questions and answers, and you can just send them in. So I'm going to get out of this, and Ted will share his screen with you.
Okay, where's my Can you see the, hold on. Do you see the PowerPoint? Okay, great. Good afternoon, everyone. My name is Ted Schneider, and we are going through the update for employment laws in 2022. There's a couple new laws affecting employers' rights with regard to severance and settlement agreements. For a little while now, we've had a law that says you cannot ask an employee to sign a confidentiality or non-disclosure agreement if the conduct that's being settled or being the subject of the agreement is sex discrimination or sexual harassment. This is to avoid the NDA to silence the victims of sexual harassment, to silence these secret settlements. So this law now has been expanded, not just to prevent confidentiality around sexual harassment allegations, but any allegation based on a protected class, which includes race, national origin, disability. So if you want, very common for employers to ask employees to sign non-disparagement agreements, for example, in connection with either exit of employment or in a hiring situation. You can still have non-disparagement and confidentiality agreements. However, they have to specifically carve out the employee's right to disclose unlawful conduct in the workplace. So if you have a severance agreement, you pay an employee money on termination in exchange for a release of their potential claims against you as the employer, and you include a confidentiality agreement. Well, you now need to include a specific carve out in that severance agreement and in any other confidentiality agreement that says this does not apply to unlawful conduct in the workplace, to the disclosure of unlawful conduct in the workplace. It doesn't have to just relate to sexual harassment. You can still keep the amount of the settlement confidential, but the factual underlying basis for the claim cannot be kept secret if it is unlawful conduct. Record retention, along that same vein, employees sometimes take some time before they can bring a claim against an employer for harassment or discrimination. So the law now requires that employers retain records relating to the hiring, firing, discipline, promotion, compensation, any kind of record related to the employee's performance for 4 years, not 2. So that's important to update your personnel file retention policies. This is to conform with the extended statute of limitations that Roy talked about a little while ago, which is now 4 years for DFEH civil rights complaints. Retention and rehiring. SB 93 does not apply to all employers. This applies to employers who are in the hotel, hospitality, airports, janitorial, and building maintenance businesses. Any type of those service providers, if you laid off your employees in 2020 or 2021 due to COVID-19, and you are now going to rehire that position, then you first have to offer the job to the worker that was laid off during COVID-19. The worker has 5 days to respond to your job offer, and if they don't accept it, then you can open it up to other applicants. Also, this only applies to employers that have more than 100 employees. If you have a question about rehiring after COVID termination, please let us know. Worker classification, there's a new rule that if you're a warehouse distribution center, this is sort of targeting the Amazon warehouses, but it doesn't just apply to Amazon warehouses. It's actually fairly broad to apply to any business that's primarily sells product online. Again, this only applies to employers with 100 or more employees, so only the larger employers. But you can no longer, if you are a warehouse distribution center, you can no longer have quotas that are not very clear and specific and presented to your employees in writing ahead of time. The quotas cannot interfere in any way with the employee's ability to take their meal breaks and their rest breaks, or to go to the restroom. And employees now have a right to complain about their quotas. If you hire a new employee, you have to give them the quotas in writing, and your existing employees all need to have the quotas in writing. And you cannot take an adverse action against an employee at a warehouse distribution center for failing to meet their quotas until they've at least received a written warning. So again, this is a pretty significant change if you are in the warehouse distribution business. Our favorite, AB5, this was the ABC test that the progeny of Dynamex decision from the California Supreme Court makes it very hard to classify workers in California as independent contractors. Almost anybody that you engage in California to do work for you is going to need to be your employee. However, as you know, there are a number of exemptions to this general rule for certain industries and certain types of workers. The law AB 1561 and 1506 was just expanded to include certain construction industry subcontractors, insurance claims adjusters, and manicurists are now excluded from the ABC test. They go to the traditional Borello control test to determine whether they're independent contractors. And newspaper carriers can now be classified as independent contractors without going through the ABC test, which we've talked about extensively in prior seminars. Please feel free to reach out if you have questions. Again, on Dynamex, again, on the ABC test, we have a new case that came out of the California Supreme Court, Vasquez versus JamPro Franchising, which provides that Dynamex and its decision are retroactive. So it doesn't matter that you've been classifying a worker as an independent contractor for years and years, and that was done prior to the ABC test. If that worker no longer is a proper independent contractor, then they need to be converted to an employee. So the law is retroactive, and that's really important note. Okay, now let's get to the COVID-19 updates, which are confusing. So I'm going to go through what the state of the law is today. That might not be what it is tomorrow or the next day or next week, because these rules, as you know, are constantly changing and they change daily. So there was AB 654. This is just a sort of semi-straightforward issue, which if you have an outbreak at your office, which is 3 or more positive COVID cases at your work site, then you have 1 day to give that notice to the public health authority and your other employees. If you are reporting an outbreak, you have to communicate that outbreak to your employees and to the public health department within 1 business day. This is helpful, SB 336. When the California Department of Public Health issues new guidance, this law does require them to publish those orders on their website with guidance as to the effective date, so we can more easily access what the current health guidance is. So what is that current health guidance? As we know, there's two different OSHAs. There's a federal OSHA and there's a Cal OSHA. We only listen to the Cal OSHA. The federal OSHA had two mandates that affected California businesses, but no longer. One was any business with more than 100 employees was required to have all of their employees be vaccinated. That 100 employee vaccine mandate was blocked by the Supreme Court a couple of weeks ago. So that's no longer the rule. And the federal OSHA also had a requirement that if you are a federal government contractor, you were required to have a mandatory vaccination policy that was supposed to take effect on January 4th. That rule has also been revoked or stayed given the Supreme Court decision. However, I think it's important for employers to plan for these types of federal mandates to work their way back into the law. I imagine they'll come back. Many businesses did implement vaccine mandates to comply with these federal rules. You can continue to keep those mandates in place. There's absolutely nothing that prohibits an employer from having a vaccine mandate. So just because it's no longer required by the federal government doesn't mean you can't voluntarily implement the vaccine mandate. And you need to be careful because you may have contractually agreed to the vaccine mandate, because when the federal contractor mandate went into effect, the contracts were updated to include a requirement that the employees of your subcontractor, if you're the prime contractor, or you as the prime contractor vaccinated your employees. So if you have a contractual obligation to vaccinate your employees, you still need to comply with that. Also, healthcare workers are still required to be vaccinated. That the Supreme Court did not touch that part of the decision. And airlines still have a valid COVID-19 vaccination mandate as well. And if you do have a vaccine mandate, you still have to provide reasonable accommodation for those who are not able to be vaccinated due to a medical condition with proper documentation or sincerely held religious beliefs. And you provide reasonable accommodation to those employees, which may be unpaid leave of absence to avoid potentially infecting the rest of the workforce. Okay, so this is the big one in terms of what's changed recently, because on January 14th, Cal OSHA, the California version of OSHA, put out a new ETS, which is called the Emergency Temporary Standard. And this ETS is set to go through April 14th. What this ETS did was kept some rules the same and changed some rules with regard to cases in the workplace and what employees need to do if they're exposed. Let me just go through this. So the first thing that's important to note is if you look at the Cal OSHA website and you look at the Cal OSHA rules, they have a lot of exclusion rules in terms of if an employee tests positive for COVID-19, they have time frames for how long they have to be excluded from work. They also have rules regarding vaccinated or unvaccinated. Well, you can ignore all of the Cal OSHA rules with regards to COVID-19 in the workplace because the governor signed an executive order that said that if the California Department of Public Health's rules are less restrictive than Cal OSHA's rules, California DPH, the Department of Public Health's rules, will control. And as it turns out, the California Department of Public Health rules are looser, don't require as long a period of quarantine as the OSHA rules do. So therefore, we will only look at California's Department of Public Health rules and not OSHA's rules. I know, it's confusing. So one of the first important changes to note is with respect to the distinction between testing for vaccinated and unvaccinated workers. If you have, that's been eliminated. If there is a close contact at work, meaning one of your workers tests positive and other workers who are in the same work site were within 6 feet for more than 15 minutes of that positive worker, you are now obligated as the employer, regardless of vaccine status, to provide tests to all workers who were in close contact with the positive case. You have to provide the tests and you have to pay for the time spent taking the tests. And if it's an exposed group, you have to pay to have the entire group of employees at that work site tested. You also have to provide information about benefits for those individuals who may have a close contact with COVID-19, including exclusionary pay benefits through Cal/OSHA. Also, another change is on face coverings. Couple of things. You should not allow your employees to wear cloth face masks any longer, because if you allow a cloth face mask, you are now required to have that mask tested with, it's called the light test. You have to hold the mask up to a light source, not clear yet on how bright the light source needs to be or how far away you're supposed to be standing. And if any light shines through the mask, it is not an acceptable mask. Well, you don't have to worry about that whole light test thing if you just require all of your employees to wear N95 masks, no more cloth masks. Another change is on, you still have to have screening in place for your employees at the work site, COVID-19 screening. And if you do that screening, that daily screening indoors, everybody who's involved in that screening must wear a mask at all times. Now, that doesn't really change much because we have through, I believe, February 14th, California has, in Ventura County specifically, has an indoor mask mandate for any activity indoor. So OSHA's update on face masks for COVID screening time is not really important, because if you're indoors, you've got to wear a mask. But we've got to make sure we don't have cloth masks. They've also updated the definition of testing. We used to say when an employee needed to get tested, they could just take a home test. Now that's no longer the case. If an employee is entitled to a test, or we need to rely on a test for the employee to return to work, and I'm going to get into those exclusion rules in a minute, the test has to be an approved test, and it also has to be either observed by the employer or by the authorized telehealth proctor. So some home tests that you buy, you actually take the test in front of a telehealth proctor through a video conference. That is acceptable. Or if the employer observes the test, that is acceptable. But if the employee takes the test at home on their own, that is not acceptable. You cannot rely on that test to allow the employee to come back to work. Okay, so what are the exclusion rules? This is a handy chart that will guide you through the isolation and quarantine periods. If a worker tests positive for COVID-19, regardless of their vaccination status, they have to stay home for at least 5 days. They can come back to work after 5 days if they have no symptoms and test negative. Again, test negative with either an employer supervised test or a authorized telehealth proctor. And then they can come back to work. If a worker either doesn't get a test, can't test, or refuses to test, then they have to stay home for 10 days. You can come back to work after 10 days with no symptoms, or if your symptoms are resolving, then you can come back to work after 10 days. You also have to wear a face mask at all times for a total of 10 days from your positive test. One thing to keep in mind is if you have a fever, it doesn't matter how many days, If you have a fever, you can't come to work. So when I say if a worker tests positive for COVID-19 and their symptoms are resolving after 5 days and they test negative, well, if they have a fever, they still can't come to work. Otherwise, you can come to work. Now, if you notice, there's no longer a distinction between vaccinated or unvaccinated for positive tests. There is a distinction if there is an exposure, a close contact between vaccinated and unvaccinated. Unvaccinated workers who are exposed to somebody with COVID-19 have to be excluded from the workplace, have to stay home for 5 days, and they take a test on the 5th day. If they test negative and have no symptoms, they can come back to work after 5 days. This is someone who's unvaccinated and exposed. If they decline to test or can't test, they have to stay home for 10 days. If they have symptoms, obviously they have to stay home until their symptoms resolve and they can take a negative test. Now, this is different for those who are vaccinated. Now, there are a distinction between whether you are fully vaccinated and boosted or fully vaccinated and not yet booster eligible, or if you're vaccinated, booster eligible, but you never got your booster. If you're vaccinated and booster eligible, but you never took your booster, then you can, and you're exposed to somebody with positive COVID-19, then you can stay home. You must stay home. You don't have to stay home from work as long as you're asymptomatic and you take a test between 3 and 5 days after the exposure. And assuming that test is negative, you can just continue to come to work. Again, face coverings at all times in any of these situations for 10 days. You always have to wear face coverings for 10 days after any exposure. Obviously, if the person who's exposed develops symptoms, then they have to stay home. Now, what if you are fully vaccinated and boosted, or fully vaccinated and not yet eligible for the booster, which is usually, I think, around 5 months, depending on Moderna or Pfizer, 5 or 6 months to get the booster. Then if you're exposed to someone with COVID-19, you don't need to quarantine. You keep coming to work. As long as you are asymptomatic, you take a test on the 5th day after your exposure. As long as that test is negative, you just keep coming to work. Face coverings, and obviously if you develop symptoms, then you're excluded from work. Okay, so those are really the key takeaways on these isolation periods are the 5-day and the 10-day. 5-day isolation period, if you can test negative after 5 days. And if you don't test negative after 5 days, it's a 10-day isolation period. And again, the tests are more complicated now. It has to be employer observed or a telehealth proctor. Okay. Right, so fully vaccinated and boosted or not yet booster eligible, as long as you're asymptomatic, you just keep coming to work. And then you take a test on the 5th day. Okay. Some of the things that haven't changed, okay, we'll get to that. First, let me talk about the compensation for those employees either being tested or if you have a mandate for a vaccine. If you are testing during normal working hours or vaccinating during normal working hours, that is paid time. If the testing or the vaccination occurs outside of normal working hours, then that's still paid time, but only if it is a requirement of the job that there be vaccination or testing done. It is paid time. So this is new and important that employers know that they need to pay their employees for time spent being vaccinated or tested as a job requirement. Unchanged requirements, you still need to have your COVID-19 prevention plan in place. You have to have a hand washing and cleaning regimen. These requirements have not changed. It's a good idea to pull out and refresh everybody on your COVID-19 policy in terms of hand washing, sanitizing surfaces, mask wearing, make sure you have enough time during the day for employees to wash their hands, make sure there's enough time during the day for employees to clean and sanitize common area surfaces. You still have to notify the public health department within 1 day and the employees. So that hasn't changed. Okay. I think those were the main points that I wanted to hit. Yeah, training and instruction. Yeah. So, and then yes, offering COVID-19 testing is new. So that is, I believe, everything on COVID. It looks like we have some chats here. And we probably have time now for some questions. So let me open it up to questions. Or I could say, let's see how we do that on the chat, or is that through Angela? Let's see, I can look at the chat here. All right, looks like most of your questions have been answered. If anyone has a question that they'd like to ask, go ahead and type it in. Oh, here, for employees excluded from the workplace due to positive tests, should they get paid for the time off? After there was, yeah, so this is confusing. Yes, so there was supplemental paid sick leave that was enacted in California, but that expired last year. That's gone. However, under these OSHA rules, there's something called exclusion pay. We're still analyzing it. This literally came down today. OSHA posted a new FAQ on their website. And it appears that if an employee is being excluded from the workplace because of COVID-19 that they received or that they were exposed to at the workplace, that employee is entitled to exclusion pay, and it's essentially their regular rate of pay. But we'll have to stay tuned for some additional detail on what that exclusion pay looks like, how long does it go, and what are the criteria for receiving it. Good question. There is no more supplemental paid sick leave, however. This would just be through OSHA, something called exclusion pay. Let me see. It looks like, I don't understand if there's been an exposed employee who's been boosted and has not been boosted. Yeah, it's a good question. This is the chart that's actually on the Cal OSHA website. And, you know, I also read this over and over again. You know, it seems like the only difference is that if you are booster eligible but not yet boosted, then you can take a negative test between 3 and 5 days after the close contact. And if you're boosted or not yet booster eligible, then you have to take your test on day 5. Don't ask me why. Is an outbreak considered when there are 3 or more employees with positive test results at the same time? It's not at the same time, it's within a 14-day period. How can one determine where exposure happened? Good question. If you have an exposure at the workplace and there's a positive test, a positive case at the workplace, and then a coworker tests positive, it's presumed that that was a workplace exposure. It's a presumption. I'm a sole proprietor in the food drive of 2 employees. Do I need to have a COVID response plan? With 2 employees, you still need to. I don't think there's any employee threshold for having your COVID-19 program. Okay. Is there any other questions? How does AB5 define what a company is when hiring another? Okay, that's complicated. I'm cutting out. Is that a problem? I'm cutting out. Is 3 dependent upon organization size? No, it's not dependent on organization size. Any other questions? If not, then I think we can go ahead and wrap up. I really appreciate that everyone joined us this afternoon. I hope it was useful. I hope you were informed a little bit on the ever-changing landscape of employment law in California. Stay tuned. We'll probably publish a blog on our website about the OSHA exclusion pay issue because, like I said, is brand new. And with that, I think we will go ahead and end the webinar unless my dad has anything to add.
Okay, only if there are some questions, we're running out of time. Please feel free to email us. We'll respond to your questions that way. We didn't get time to answer all of them. Very good questions. I know you're all confused. But feel free to email us. Our marketing director, Angela, will email you all information about getting the PowerPoints. And you can email to her and say you'd like more information on such and such, and we'll help respond. So have a great day, and thank you all for joining us.
Thanks, everyone. And the PowerPoint will be going out to the participants. And if you don't receive the PowerPoint, feel free to email Angela at our office. And have a great rest of your week, everyone.